Welcome to the Deep Dive, where we sift through the noise, examine the core sources, and extract the essential knowledge you need to be truly well-informed. Today, we're diving deep into a topic that reaches into the very foundations of American democracy. We're talking about the intense, ongoing tension between federal power and state authority over the U.S. election process. This isn't merely about policy, it's really about the fundamental architecture of how we choose our leaders, a system built on, that delicate balance called federalism.
That's exactly right. What we're witnessing is indeed a profound test of that federalist system. It was really ignited by a sweeping executive order from March 2025. It represents, a bold attempt to reshape election administration, and it's one that immediately met with some pretty decisive judicial pushback. And in parallel, the Justice Department embarked on this unprecedented dragnet for voter data, which in turn sparked robust resistance from states.
Okay, so our mission for this deep dive is to methodically unpack these complex layers. We'll start by analyzing President Donald Trump's March 25th executive order. We'll get into the specific provisions, its intended impact on everything from, say, voter registration to counting mail ballots. Then we'll trace the swift judicial response, exploring how the courts have acted as, a crucial bulwark against what many saw as executive overreach.
Right. And we'll also examine the Justice Department's parallel voter fraud initiative. We'll scrutinize the scale of its demands for state voter data and the bipartisan pushback it's received.
And to really contextualize these domestic developments, we'll draw some, I think, illuminating parallels. We'll look at international examples like Hungary and Brazil.
Yep.
And also a significant domestic precursor, the fake electors scheme back in 2020.
Those comparisons are really vital for understanding the kind of evolving playbook for undermining electoral systems, often through, legalistic manipulation and the insidious erosion of public trust.
And finally, we'll critically dissect the election integrity claims that underpin these actions. We'll compare them against the factual reality, the data. This will lead us to a discussion of the profound, unresolved questions about federal power and, of course, the future risks to public confidence in our electoral system.
Exactly. We're going to explore the constitutional underpinnings, the practical mechanisms of election administration, and that philosophical tension, really, between centralized power and decentralized governance, all of which is crucial for you, the listener, to navigate the complexities of this evolving landscape.
Okay, let's unpack this. Hashtag TAE. The sweeping March 25 executive order and its initial rebukes. Let's begin with the executive order itself, signed by President Trump on March 25, 2025. It was titled, Preserving and Protecting the Integrity of American Elections. And our sources describe it as, nothing short of a sweeping federal intervention in election administration, which is, truly extraordinary when you consider the long-standing, deeply rooted tradition of states primarily managing their own elections.
Indeed. The title itself sets a tone, right? It frames the order as a necessary measure for safeguarding the electoral process. However, its specific provisions immediately signaled a significant departure from established legal frameworks and, frankly, the federal-state power dynamics we're used to. Its core mandates attempted to fundamentally alter election administration in ways that have traditionally fallen under state jurisdiction, with Congress holding supervisory power for federal elections and, crucially, not the president having that direct role.
Okay, so what were the most significant provisions, the ones that immediately sparked contention?
Well, one of the foremost was a new mandate for proof of citizenship to vote. The order directed that voters must provide documentary proof of U.S. citizenship. We're talking things like a passport, maybe a birth certificate, specifically when using the federal voter registration form.
A passport or birth certificate.
Oh, okay.
Yeah.
And this represented a monumental shift. It marks the first time such a document would be required for federal voter registration.
And how does that compare to the system we have now, or, the system that was in place before this order?
So the existing federal voter registration form, the NVRA form, it only requires applicants to attest to their citizenship under penalty of perjury.
Okay, so you swear you're a citizen.
Right. And you also provide a driver's license number or a social security number. And that allows for database checks against existing state and federal records. So voting rights advocates, they immediately sounded the alarm. They warned that this new requirement could disenfranchise millions of eligible Americans.
Millions. Wow.
Yeah, particularly those who don't possess passports or readily available birth certificates. Acquiring these documents can be a significant hurdle for many people, especially, the elderly, low-income individuals, maybe people born outside of traditional hospital settings. It highlights a really critical practical and demographic impact.
Okay, so that's the proof of citizenship part. But beyond voter registration, the order also targeted mail ballot deadlines, right?
It did, yeah. It mandated that no mail-in ballots arriving after Election Day can be counted. It asserted that all votes absolutely must be cast and received by Election Day itself.
Which seems on its face to directly contradict laws in quite a few states.
It absolutely did. This provision directly flew in the face of established laws in at least 18 states, plus D.C. and U.S. territories.
Yeah.
These places explicitly accept ballots that are postmarked by Election Day and count them if they arrive within a short grace period afterward.
Right, those grace periods are pretty common.
They are. So the practical implication here was to unilaterally override these established state deadlines and abruptly, quote, invalidate legal votes that states would otherwise count. It just disregarded the very real logistical challenges of mail delivery, especially for folks in remote areas or military personnel serving overseas. For them, these grace periods are essential to make sure their validly cast votes actually get counted.
So the intent, it seems, was to just remove any flexibility that states had built into their systems.
Regardless of the impact on
Yeah.
legitimate ballots, yeah, that seems to be the implication.
Okay. And then the order took aim at an independent body, the Election Assistance Commission, the EAC.
Right.
It ordered the EAC to revise the federal voter registration form to implement that proof of citizenship mandate we just talked about. But it went even further than that. It commanded the EAC to decertify all voting machines currently in use nationwide.
Yeah, that was the big one.
And it prohibited recertification unless those machines met new stringent standards that are currently unmeetable. That sounds like quite a move against an independent agency.
Oh, these directives to the EAC were truly extraordinary. I mean, the EAC is a bipartisan commission. It has very limited regulatory power. Congress, not the president, tasked it with supporting state election administration, not imposing federal mandates or, unilaterally decertifying equipment nationwide.
So it directly tests the separation of powers.
Absolutely. The president was essentially attempting to use an executive order to dictate the actions of a body designed by Congress to operate with a degree of independence, and the idea of demanding unmeetable standards for decertification. Well, that basically creates a mechanism for systemic failure.
How so?
It could potentially throw the entire electoral system into chaos by making it impossible for states to use their existing certified machines.
Wow, okay. And to try and ensure compliance with all of this, the order also threatened federal funding.
Yes, it attempted to condition federal election funds on state compliance. It warned that states refusing to adopt the new proof of citizenship rule, or those continuing to count late-arriving ballots according to their own state laws, could see their federal election funding withheld.
Now that sounds legally questionable right off the bat.
It is highly problematic from a constitutional perspective. Congress controls the federal purse strings, not the president. The EAC's funding authority, for instance, that's set by laws like the Help America Vote Act, HEA. So an executive attempt to tie federal funds to entirely new conditions imposed by the executive branch. That's a likely violation of the separation of powers. It's, a clear attempt to use financial leverage to bypass legislative authority and compel states to act against their own laws. It's effectively trying to centralize power in an area that's traditionally decentralized.
Okay, so unsurprisingly, this sweeping federal intervention, as you called it, immediately triggered a wave of legal challenges and state pushback.
Right.
The courts wasted no time in responding. What was the initial judicial blow?
Precisely. One of the first significant legal actions came from voting rights groups and the Democratic National Committee. They sued in D.C., arguing the order would, quote, deny eligible citizens the vote. And on April 24, 2025, so just about a month after the order was issued, U.S. District Judge Colleen Collar-Cotelli delivered an early blow. She partly enjoined the order.
Partly enjoined. What does that mean specifically?
It means she blocked certain parts of it, specifically finding that Trump had overstepped his authority in those areas.
And which specific aspects did she block?
Judge Collar-Cotelli blocked the enforcement of any requirement that federal officials verify voter registrants' citizenship or that voters show citizenship documents. Her legal reasoning was explicit and really foundational. She stated, the U.S. Constitution gives states, not the president, the power to oversee elections.
A clear reaffirmation of the established constitutional framework.
Absolutely. But It's crucial to note that at that initial stage, she did not halt the order's ban on late arriving ballots.
Oh, okay.
Nor did she stop the directive for federal agencies to share data with this new Department of Government Efficiency to hunt for non-citizen voters.
Interesting. Why did she leave those parts unblocked initially?
Well, her reasoning was that the president can instruct executive agencies to share information internally. That's generally seen as within executive power.
Yeah.
And as for the mail ballot deadline, she reasoned that states themselves, not advocacy groups, needed to be the ones to challenge that specific rule in court. They had the direct standing.
Gotcha. So it left the door open for more lawsuits.
Exactly. It signaled that while some aspects were clear overreach, others required different plaintiffs, or perhaps different legal arguments.
And those further challenges did, in fact, come just a couple of months later, right? June 2025.
That's right. 19 Democratic-led states, spearheaded by their attorneys general, filed suit in federal court in Massachusetts. They asserted, quite forcefully, that the EO trampled on state sovereignty.
And this led to a bigger rebuke.
This is where Judge Denise Casper delivered what our sources call a more comprehensive rebuke to the order. Her ruling was a far broader injunction. She blocked enforcement of both the proof of citizenship registration mandate and the Election Day receipt deadline for mail ballots.
Both key provisions.
Both. And her legal reasoning was even more emphatic, perhaps, than Judge Collar-Cotelli's. She firmly declared that the Constitution gives power over federal elections to Congress, and Congress had never authorized these executive-imposed changes. What's particularly notable here is her explicit observation that, quote, the president does not feature at all in the Constitution's assignment of election powers.
Wow, that's a powerful statement, just really emphasizing the limited constitutional role of the executive in this specific area.
Absolutely. Judge Casper specifically noted that federal law, the National Voter Registration Act, or NVRA, purposefully does not require documentary proof of citizenship. And she also noted that nothing in law bars states from counting valid ballots postmarked by Election Day.
So she's pointing out that EO was trying to impose restrictions Congress itself chose not to make.
Exactly. It underscores that the executive order was attempting to create requirements that Congress hadn't mandated. Her injunction even went a step further.
Yeah.
It prohibited the Department of Justice from pursuing civil or criminal enforcement of the order against non-complying states.
That's a significant protection for the states.
It is. It essentially shielded states from federal prosecution for adhering to their own existing laws, even if they defied the executive order.
So she clearly saw the practical implications of this order, too, beyond just the legal theory.
Indeed. In Judge Casper's view, the contested sections of the order would have burdened states with significant costs to overhaul registration processes. And, critically, they would impede the registration of eligible voters, many of whom, as we discussed, lack ready access to documents like passports or birth certificates.
So a holistic view.
Yes, considering not just the constitutional infringement, but also the real-world detrimental impact on both election administration and, crucially, voter access. While the administration has appealed at least the Massachusetts injunction, the courts have clearly signaled a strong intent to guard state election prerogatives against unilateral federal interference.
Okay, let's pause here for our first micro recap. We've dug into President Trump's March 25th executive order, this sweeping federal intervention. Key parts included mandating proof of citizenship for federal registration, banning the counting of mail ballots received after Election Day, directing the EAC to make changes and decertify machines, and threatening state funding.
Right, and we saw immediate pushback. Voting rights groups and states sued. Judge Collar-Cotelli in D.C. partially blocked the order, focusing on the proof of citizenship part, saying the president overstepped constitutional authority given to states. But she initially left the mail ballot deadline and data sharing parts untouched, saying states needed to challenge the ballot rule directly.
Then Judge Casper in Massachusetts issued a broader block, hitting both the proof of citizenship and the mail ballot deadline provisions. Her reasoning was even stronger. The Constitution gives election power to Congress and states, not the president, and Congress never authorized these changes. She even blocked DOJ enforcement.
Exactly. So, two federal judges emphatically pushing back on the idea that the president can unilaterally rewrite election rules set by states and Congress. Mega recap plus flashcard bullets, Section 1.
All right, that wraps up our deep dive into the executive order itself and those initial, very significant judicial rebukes. If we were boiling this down for, say, flashcards, what are the absolute key takeaways from this section?
Okay, good idea. First flashcard, definitely. State authority over elections. The U.S. Constitution gives states primary authority. Congress has supervisory power for federal elections. Critically, the president has no direct constitutional role in setting these rules. The courts really hammered this point home.
Got it. State authority first. What's next?
Second, federal voter registration form requirements. Remember, the existing NVRA federal form requires attesting to citizenship under penalty of perjury, plus providing an ID number like a driver's license or SSN for verification. It does not require bringing in documentary proof like a passport or birth certificate. Changes to that form require a process involving the bipartisan EAC and state input, not a presidential order.
Okay, so the current system relies on attestation and database checks, not upfront documents. Third point.
Third flashcard. Many states count late arriving ballots. This isn't some new or controversial thing. At least 18 states plus D.C. and territories accept mail ballots that are postmarked by Election Day, even if they arrive a few days later within a set grace period. There's no evidence this practice leads to fraud, and the president can't just override those state laws by executive order.
Right. So the ESA tried to change established state practices. Those seem like the core conflicts.
Absolutely. A sweeping order trying to alter fundamental aspects of registration and voting, met by swift judicial pushback grounded in the Constitution's allocation of power. #CHAG2. The attempted co-option of the Election Assistance Commission, EC.
So we've seen the swift legal battles erupt around the executive order itself, but the administration also took this unique approach by attempting to leverage an often overlooked but crucial independent body, the Election Assistance Commission, or EAC. Can you tell us more about the EAC's intended role and how it suddenly found itself right in the crosshairs of this executive order?
Sure. The EAC was created by Congress back in 2002 through the Help America Vote Act, HAVA. This was largely in response to the fallout from the highly contested 2000 presidential election. It was specifically designed as a bipartisan independent commission. Its core purpose is really to support election officials, improve the administration of elections, and help Americans participate.
Support, not direct.
Exactly. It serves several key functions: setting voluntary voting system guidelines, certifying voting machines to ensure they're secure and accurate, maintaining the federal voter registration form we just talked about, and acting as a national clearinghouse for best practices in election administration. Think of it as a resource center.
So it's really meant to be a helpful, neutral resource for states, not like a tool for federal control.
Precisely. And crucially, the EAC was deliberately structured to be insulated from direct White House control.
How so? What's the structure?
Its composition reflects this intent. There are 4 commissioners, and no more than 2 can belong to the same political party. And while the president formally nominates commissioners, congressional leaders actually recommend candidates, and then the Senate confirms them.
Ah, so a layered appointment process.
Right. It's designed to ensure its nonpartisan nature. And by design, the EAC's regulatory powers are limited and explicitly require bipartisan consensus. For example, changing that federal registration form, which was a major point of contention in this executive order, requires input from the states, a public comment period, and approval by at least 3 of the 4 commissioners.
3 out of 4, so it needs bipartisan buy-in.
Exactly. It's a deliberate legal framework to prevent unilateral action by one party or by the executive branch.
Okay. Despite this clear structure, Trump's executive order, as we saw, really treated the EAC as an arm of the presidency.
It did.
It directly directed the EAC to implement the new citizenship document mandate on the federal form, and it even tried to get them to enforce state compliance with this new rule. And then there was the command to decertify all voting machines currently in use nationwide. That's quite a departure from its intended role as a support agency.
It's an unprecedented attempt to bypass the EAC's statutory independence. And initially, it actually appeared the EAC was beginning to comply, or at least exploring how to comply.
Really? How did that manifest?
On April 11, 2025, the EAC's executive director at the time, Brianna Schlutz, sent a letter out to state election officials. It was seeking consultation on how they would implement a proof of citizenship requirement if the order stood. The language of this letter was particularly telling. It explicitly described Trump's order as providing instruction to the EAC, which signaled that the commission, or at least its leadership then, considered itself bound by the executive order.
So it wasn't pushing back initially.
The letter even asked states about the potential impacts on registrations and what states would need to do for enforcement. It read like they were preparing to follow the order.
And this move must have created a real headache for the Justice Department, right, given their ongoing legal arguments in court.
Oh, it absolutely undermined the DOJ's litigation position. At that very time, DOJ attorneys were arguing in court that no federal agency had actually taken action yet based on the EO.
So they were saying the lawsuits were premature.
Exactly. They argued an injunction wasn't needed yet because nothing had happened. The plaintiffs, of course, immediately seized on the EAC's letter as undeniable proof that implementation was already underway. It directly contradicted the administration's claims in court.
I bet the judge noticed that.
Oh, yeah. Judge Kohler-Cotelli, in an April hearing, was decidedly skeptical of the DOJ's dismissals. She noted that the EAC letter had formally put states on notice that the commission viewed the EO as a mandate. So this letter, whether it was intended that way or not, became a key piece of evidence against the administration's legal defense that the EO hadn't had any real effect yet.
So this attempted hijacking, let's call it, of the EAC drew sharp criticism from, well, pretty much all sides.
Yes, it did. Voting rights organizations like the Biden Center, the ACLU, they publicly urged the EAC to refuse to comply. They argued correctly that nothing in the EAC's founding statute or the Constitution empowers a president to simply dictate its actions like this. They warned the EAC was being turned into a political weapon rather than remaining the neutral support agency it was intended to be.
And the history and design of the EAC itself kind of run counter to these commands.
Completely. Congress intended the EAC to support, not supplant, state control over elections. The current commissioners, who have decades of experience in actual election administration, they were never meant to be enforcing top-down federal edicts against the states they're supposed to be helping.
And as we've already heard, federal law, specifically the NVRA, actually limits what the EAC can require on the voter form anyway.
Exactly. A notarized proof of citizenship, as mandated by the executive order, is simply beyond the limits set by Congress and the NVRA. The legal constraints are quite clear.
So did the EAC end up complying, or did it push back?
Fortunately, by June 2025, especially after those injunctions from Judge Kohler-Cotelli and Judge Casper came down, the EAC pulled back significantly. Our sources say they stayed within the bounds of its authority. They refrained from actually changing the federal registration form or moving forward with decertifying machines in defiance of the court orders.
Okay, so the courts were key here again.
Absolutely. But this whole episode rang loud alarm bells. It really revealed just how vulnerable even an independent commission, one designed for bipartisan consensus and insulation from political pressure, could be when faced with direct executive pressure. It truly took judicial intervention to hold that line and protect the EAC's statutory independence. It was a close call, arguably. Mega recap plus flashcard bullets, Section 2.
Okay, that brings us to the end of our look at the Election Assistance Commission's role in this. Another key flashcard moment, I think. What's the core takeaway about the EAC?
Right. The main flashcard here has to be Election Assistance Commission, EAC, independence. Remember, it's an independent bipartisan commission created by Congress specifically to assist state and local election administration.
Not to be directed by the White House.
Exactly. The president cannot unilaterally direct its policies. Major actions, like changing the federal voter form, require specific legal procedures, including state consultation, public comment, and, crucially, bipartisan support from the commissioners themselves.
And attempts to command it were seen as legally dubious.
Yes. Attempts by a president to command the EAC raised serious legal issues under the separation of powers doctrine, and as we saw, those attempts were ultimately blocked by the courts in this instance. The judicial branch stepped in to reinforce its statutory independence. #3, the DOJ sweeping data demands and state pushback.
So, the courts were quick to act against the direct mandates of the executive order and those attempts to leverage the EAC. But the administration wasn't just relying on those avenues. In a parallel move, the Trump administration's Department of Justice launched what our sources are calling a sweeping voter fraud dragnet.
That's right.
And many state officials, importantly, cutting across the political spectrum, viewed this as pretty unprecedented federal overreach.
That's exactly right. Over the past few months leading up to our sources reporting on this, the DOJ's voting section initiated this really extensive campaign. They sent an array of letters, emails, and calls to at least 19 states, according to an Associated Press count. The requests were for extensive election data, far beyond what's typically seen in federal-state interactions on elections.
19 states. Wow. And what kind of data were they asking for specifically?
Well, specifically, at least 15 states, and this included a mix, right? 9 Democrat-led, 5 Republican-led, and 1 with a bipartisan election board. They received demands for their entire voter registration list.
Wow, entire voter registration lists. That's a huge amount of sensitive data. Was it just the lists?
No, and it wasn't just lists. They also asked really detailed questions about how states maintain their voter rolls. Things like how they handle duplicate registrations or remove deceased voters. Often they were referencing data points from a recent EAC survey as a sort of justification.
Okay, probing state procedures.
Yes, and what's particularly noteworthy is that in at least 7 states, DOJ lawyers sought to set up calls to discuss information sharing agreement, the purpose, to report instances of election or voter fraud. The clear aim here was to effectively recruit states to help enforce federal election laws and protect integrity of elections. It was casting states as federal agents in this hunt for fraud.
So, trying to get states to proactively report to the DOJ.
Exactly. And just to underscore the seriousness or perhaps the intent, one senior counsel in DOJ's criminal division was involved in these outreach emails. That signals that justice was treating this as a potential law enforcement matter, not just an administrative inquiry or a cooperative data request.
That scope sounds really, truly unprecedented compared to historical norms. What do election officials and experts say about this kind of demand? Does it fit with the DOJ's traditional role?
It's seen as highly unusual, yes. For example, in Colorado, the DOJ didn't just ask for lists, they demanded all records relating to the 2024 election and any records retained from the 2020 election.
All records. That's incredibly broad.
Think about that. It's not just voter lists, but potentially ballots, internal emails between election officials, audit logs, truly an unprecedented grab of state-level electoral data. Election officials and experts uniformly agree that this kind of broad fishing expedition by DOJ is highly anomalous.
What is the traditional DOJ role, then?
Traditionally, the DOJ's role in elections, primarily through its Civil Rights Division's voting section, has been to protect voting rights. Think enforcing the Voting Rights Act, ensuring access to the ballot for minorities, language access, things like that. It has not historically been to scour states for potential voter fraud cases without specific substantiated cause or credible allegations.
So this represents a dramatic departure from how the DOJ has historically operated in election matters.
Exactly. David Becker, who's a former DOJ voting section lawyer and now runs the Center for Election Innovation and Research, he's a respected expert. He openly remarked that the DOJ does not typically engage in fishing expeditions to find possible violations. He stressed that the department is supposed to operate with independence from partisan directives. His observation was stark. Now it seems to be operating differently.
That's a significant observation from a former insider.
It is, because it suggests a change in the fundamental operational philosophy of a key federal law enforcement agency regarding its interaction with state election administration.
So how are states responding to these sweeping demands? Are they just, handing over the data?
Not at all. There's been varied resistance, quite strong in some cases. Some states have not responded yet, likely taking a cautious approach, maybe consulting lawyers. Others have sent the DOJ publicly available versions of their voter lists. But critically, with sensitive personal data like birth dates or driver's license numbers redacted.
Okay, providing public data, but not the private stuff.
Right. Some have answered basic procedural questions about their list maintenance while explicitly refusing to hand over raw voter data. For instance, Minnesota's Secretary of State, Steve Simon, flatly told the DOJ that the federal agency is not legally entitled to the full statewide list, citing state voter privacy protections.
And it sounds like Minnesota isn't alone in that stance, suggesting a broader concern about federal overreach, not just partisan politics.
Indeed. Maine's Secretary of State, Shenna Bellows, similarly rebuffed the demand. She called it an overstep of federal bounds that would directly violate voter privacy under Maine law. She stated quite pointedly that the Justice Department doesn't get to know everything about you just because they want to.
Strong words.
And what's particularly insightful, as you noted, is that even in some Republican-led states, there's a clear wariness over the sheer breadth of information being sought. This isn't just Democrats pushing back. It's a concern about federalism and the appropriate limits of federal power coming from across the political spectrum. State sovereignty is a sensitive issue for many states, regardless of party.
So this isn't just about finding fraud, is it? It seems to coincide with a much broader political strategy linking back to the executive order and other statements.
Absolutely. The timing and scope strongly suggest a connection. The Associated Press notes that this sweeping outreach coincides with Trump's efforts to investigate past elections and influence upcoming ones. Remember, President Trump has openly called for a special prosecutor to probe the 2020 election, which he continues to falsely insist he won.
Yep.
He's also openly urged partisan state legislatures to rewrite congressional maps for more favorable political outcomes. And what's more, the DOJ letters demanding this data explicitly cite Trump's March executive order. That order, as we discussed, directed the Attorney General to pursue these Information Sharing Memoranda of Understanding, or MOUs, with states to the maximum extent possible.
So the DOJ's voter data campaign is really an extension of the White House's election integrity agenda. It's framed as treating voter fraud, which, again, all evidence shows is vanishingly rare in reality, as a top federal concern.
That's precisely it. This approach leverages federal power to scrutinize state election processes under the guise or pretext of election integrity. For state officials, especially maybe in states Trump didn't win or where margins are close, this feels very much like the federal government inserting itself into core state functions. Potentially, they fear to find anomalies that could be used to justify future crackdowns, legal challenges to results, or just sow doubt.
It really raises those fundamental questions of federalism, doesn't it?
It does. How much can a president, absent new laws from Congress, pressure or compel states in the name of election security? So far, states are steadfastly citing the Constitution, particularly the 10th Amendment reserving powers to the states, and their own state privacy laws to hold the line. Some are even joining lawsuits or filing new ones to block these DOJ efforts. As of August 2025, when our sources were reporting, the stage was clearly set for continued, intense legal battles over the appropriate scope of federal election integrity enforcement and what the federal government can and cannot demand from states regarding their election data. Micro recap. Approximates 10-minute mark of overall episode.
Okay, about 10 minutes in, let's do a quick micro recap here. We've shifted from the executive order and the EAC to the Justice Department's actions. We learned the DOJ launched a sweeping voter fraud dragnet, contacting at least 19 states.
Right, demanding unprecedented amounts of data, entire voter rolls in at least 15 states, plus detailed records, even trying to set up info-sharing agreements.
This was framed as enforcing election integrity, explicitly linked to Trump's executive order, but seen by many as far beyond DOJ's traditional role of protecting voting rights.
Exactly. It looked more like a fishing expedition without specific cause.
And the response: significant pushback from states Democrat and Republican-led, citing privacy laws, state sovereignty, and constitutional limits on federal power. Many refuse to hand over raw data,
Raising fundamental questions about federalism and setting the stage for ongoing legal fights over these data demands. Mega recap plus flashcard bullets. Section 3.
All right, that covers the DOJ's data dragnet and the state resistance. Time for another flashcard summary for this section. What are the key points here?
Okay, first flashcard for this section should probably re-emphasize state authority over elections. The pushback really highlights states guarding their constitutional turf in running elections.
Good point. It's a recurring theme.
Second, let's call it unprecedented DOJ data demands. Key here is the scope entire voter rolls, all records in some cases, requests to 19-plus states. This broad approach, lacking specific evidence of wrongdoing, is what made it so unusual compared to past DOJ actions focused on specific civil rights violations.
Unprecedented scope. Third,
Bipartisan state resistance and privacy concerns.
yeah.
It wasn't just one party pushing back. States across the political spectrum cited voter privacy laws and constitutional limits, federalism, 10th Amendment, to refuse handing over sensitive, non-public voter data they saw as federal overreach.
Bipartisan resistance. And maybe one more.
Yeah, fourth, election integrity versus reality. The justification was fighting voter fraud, but this contrasts sharply with the flashcards we could make about the actual incidence of fraud.
Like,
non-citizen voting is exceedingly rare. We'll get more into this, but non-citizens are barred by law. Documented cases are extremely uncommon, and claims of widespread non-citizen voting have been thoroughly debunked.
got it.
And voter fraud is minimal. Numerous investigations consistently find that voter impersonation, double voting, etc., are extraordinarily infrequent, certainly not enough to alter outcomes. The false narrative of rampant fraud is often used to justify stricter rules, but the data doesn't support the premise of the DOJ's broad investigation here.
Okay, great points. So the DOJ dragnet, justified by rare issues, met strong state resistance based on privacy and federalism. So these attempts at federal intervention in U.S. elections, this pressure on states and independent bodies, it's important to understand they don't happen in a vacuum. They have some, frankly, uncomfortable echoes in other countries' recent struggles with democratic norms. While every context is unique, observers are seeing parallels to how leaders in other democracies have essentially tilted the field or otherwise undermined electoral fairness. What's a key international example that helps illustrate this dynamic?
Well, what's fascinating, or perhaps concerning, here is how these leaders often employ seemingly legal or administrative levers to achieve their aims. It's not always overt cheating. Take Hungary, for instance, under Prime Minister Viktor Orban and his Fidesz party. Over more than a decade, they have systematically shaped election laws, media landscapes, and state institutions to entrench their power.
How did that play out in practice?
International observers of Hungary's 2022 election noted that while the actual election day procedures were generally professional, the overall contest was, quote, marred by the absence of a level playing field.
Okay, so it wasn't about stuffing ballot boxes on election day, but more about stacking the deck long before the votes were even cast.
Exactly. The tactics involve things like a pervasive overlap between the ruling party and the government. This means state resources were effectively used as party resources for campaigning. There was also consistently biased media coverage, with state media heavily favoring the ruling party, and murky campaign finance practices that unfairly benefited the governing coalition.
So using the power of the state to gain an edge.
Precisely. Orban's government used legal and administrative levers, everything from gerrymandering electoral districts to dominating the media narrative to effectively stack the deck. Opposition parties could compete, technically, but they did not compete on an equal footing. Critics often likened it to trying to play soccer on a field deliberately slanted downhill for one team, with the referee clearly favoring that team as well.
Okay, I see the analogy. And the U.S. parallel, how does that connect to what we're seeing with Trump's executive order or the DOJ actions?
Well, if Trump's executive order had been fully implemented, the proof of citizenship, the mail ballot restrictions, many analysts argue it could have created a mini version of this dynamic in the U.S. By unilaterally imposing rules that disproportionately affect certain voters, often those leaning towards the opposition, it could tilt the playing field. And all done under the guise of protecting elections or ensuring integrity.
So, using the form of law to undermine the substance of fair competition.
Right. Hungary's example powerfully shows how democratic processes can be subverted using the letter of the law, manipulating rules under the guise of achieving uniform standards, when the real effect is partisan advantage. Of course, it's crucial to note the U.S. system does have stronger checks and balances, more independent courts historically, a deeply ingrained federalism that provides resistance points, a freer press. But the concern is a leader using executive power to try and rig the ground rules, much as Orban has done more successfully through legislative power in Hungary's parliamentary system.
Okay, that's Hungary. Then there's Brazil and the playbook of former President Jair Bolsonaro from roughly 2019 to 2022. This is another stark cautionary tale, perhaps even closer to home in some ways.
It really is. Bolsonaro, throughout his term, ceaselessly attacked the integrity of Brazil's election system. And in many ways, he was echoing Donald Trump's baseless fraud claims, almost step for step. He particularly targeted Brazil's electronic voting machines. These have been used successfully and without major incident since 1996, but he insisted without proof that they were vulnerable to massive fraud.
And it took it to an extraordinary level, didn't he? It seems he tried to use the power and platform of his office to actively undermine public faith in the process itself.
He did, in a really brazen move in July 2022, just months before Brazil's presidential election. Bolsonaro assembled foreign diplomats for an unprecedented briefing. During this briefing, he alleged, again without providing any credible evidence, that Brazil's election system was completely vulnerable. He even went so far as to suggest that the military should run a parallel vote count as some kind of check.
Wow, suggesting military intervention in vote counting.
Yeah, and he provided zero credible evidence for these inflammatory claims. He even cited a minor hacking incident from 2018 that Brazil's own federal police had confirmed had no impact whatsoever on the election outcome. His aim, much like Trump seemed to be in 2020, was clearly to sow doubt preemptively. The goal appeared to be that if he lost re-election, he could then claim the vote was rigged against him.
And the outcome of this strategy in Brazil, did it work?
Well, Bolsonaro ultimately lost the October 2022 election to Lula da Silva. While he never formally conceded defeat, his strategy of relentlessly attacking the system bore its bitter fruit. A segment of his supporters refused to accept the results, culminating tragically in the January 8, 2023 storming of Brazil's Congress, Supreme Court, and presidential palace, a disturbing echo of the U.S. January 6 Capitol riot just 2 years earlier.
So it shows the real-world consequences of undermining trust.
Absolutely. Bolsonaro's tenure vividly illustrates the danger of an incumbent leader using both rhetoric and the powers of office to undermine trust in elections. He even attempted to get Brazil's Congress to mandate paper ballot printouts from the machines, which failed. He hinted darkly at not obeying court rulings, at one point threatening to act outside of the Constitution when Brazil's judiciary, particularly its Supreme Electoral Court, pushed back and probed his false claims.
What's the legacy in Brazil now?
A deeply polarized public and significantly damaged faith in the democratic process, especially among many on the political right who bought into his narrative.
So for the U.S., Bolsonaro's story is a stark reminder. Relentless false fraud narratives and executive pressure on election systems can generate real-world chaos and violence.
It is. And Trump's current actions, pushing the DOJ to hunt for fraud, installing loyalists in key positions who propagate doubt, reflect a very similar playbook of eroding confidence as a political strategy. This can have profound and long-lasting repercussions on democratic stability, even if specific attempts at rule changes are blocked by the courts. It's about undermining the very foundation of trust in the electoral system itself, making people unwilling to accept legitimate results.
And we don't even have to look abroad for such precedents, do we?
Right.
The 2020 U.S. fake electors scheme is a direct homegrown precursor to the kinds of pressures we're seeing now in 2025.
Indeed. America need not look abroad. The plot after the 2020 election is right here. After losing the vote, Trump and his allies orchestrated an effort in 7 key states that Biden won to submit fraudulent slates of electors, declaring Trump the winner instead. In total, 84 individuals across 7 states signed false electoral college certificates, claiming Trump had won their state's electoral votes, contrary to the certified results.
This wasn't just some symbolic protest, was it? It seems it was a serious attempt to disrupt the constitutional process of transferring power.
Far from symbolic protest. Our sources indicate this was not mere political theater, but rather part of an attempted procedural coup. The goal was to create confusion and provide a pretext to disrupt the counting of electoral votes on January 6, 2021, potentially allowing Vice President Pence or Congress to reject Biden's legitimate electors.
But the scheme failed.
Ultimately, the scheme failed, yes. Congress did not accept the fake electors, and investigations quickly began at both state and federal levels. By 2024, the legal consequences were materializing quite significantly. Dozens of those fake electors, and some Trump lawyers involved in orchestrating it, face criminal indictments in states like Georgia, Arizona, Michigan, and Nevada. Charges included forgery, fraud, and other related offenses.
It's a serious legal accountability.
Yes, these ongoing prosecutions underscore just how grave and unprecedented that scheme was considered by law enforcement, a blatant attack on the constitutional transfer of power.
Okay, so how is this fake electors episode a direct antecedent to the current situation in 2025 with the executive order and the DOJ pressure?
It demonstrated a clear willingness among certain actors to override voters' will using fake legal processes. That's the key link. Just as the 2025 executive order tried to impose onerous federal rules that could potentially skew future results, the fake electors scheme relied on creating false legitimacy. You had fake electors pretending to be official state electors.
Yeah, the theme of false legitimacy.
It's exactly. Or in 2025, you have a president attempting to claim authority to rewrite election laws that the Constitution fundamentally assigns to states and Congress. Both involve using a veneer of legality or authority to achieve an outcome contrary to established democratic processes or results. The legacy of 2020's subversion attempt weighs heavily now. It has definitely led to greater vigilance by courts, the media, election officials, and civil society groups for any new anti-democratic maneuvers.
So people are watching more closely now.
Yes, and it also means that much of Trump's current agenda, from stoking fears of voter fraud to trying to influence who counts the votes, is viewed through a lens of extreme skepticism by many, given the lengths his team went to try and overturn the 2020 election. In sum, the fake elector saga stands as both a critical warning and a direct predicate for understanding the events of 2025. There are those prepared to upend democratic processes if given the chance, making today's institutional safeguards all the more critical. Micro recap. Approximate 15-minute mark of overall episode.
All right, about 15 minutes in now, let's do another quick check-in. We just explored some really alarming parallels and precedents. We looked at Hungary under Orban, seeing how legal and administrative tools can be used to create a tilted playing field and entrench power, even without overt election day fraud.
Right, manipulating the rules and resources beforehand. Then we looked at Brazil under Bolsonaro, which showed the danger of an incumbent relentlessly attacking the election system's integrity with baseless claims, sowing doubt, and priming supporters to reject unfavorable results, leading to real-world violence.
A strategy of eroding trust. And crucially, we examined the 2020 U.S. fake elector scheme as a direct domestic precursor.
Yes, demonstrating a willingness right here at home to use fraudulent legal processes to try and overturn voters' will and disrupt the constitutional transfer of power. The ongoing indictments show the seriousness of that attempt.
So these examples really illuminate the strategic thinking behind attempts to undermine elections, whether by rigging the rules or destroying public faith, underscoring why vigilance and strong institutions are paramount. Mega recap plus flashcard bullets, Section 4. Okay, that wraps up our look at these global and domestic parallels. Really important context. Let's distill this section into flashcards. What are the key comparative takeaways?
Okay, first let's make one for international democratic backsliding examples. The key point here is that established democracies can see backsliding when leaders manipulate election rules or undermine the referees. Hungary's tilted playing field, achieved through legal changes and state resource abuse, is one model. Brazil's relentless attacks on its voting system to preemptively sow doubt is another. These show how democratic erosion can happen.
Got it. Democratic backsliding tactics. What's next?
Second, the 2020 U.S. fake electors scheme is precedent. This is critical domestic context. It wasn't just talk. It was an organized attempt to use fraudulent documents and procedures to subvert the Electoral College process and the constitutional transfer of power. It shows a willingness among some actors to go to extraordinary lengths.
A direct precursor showing intent. Anything else from this section?
Maybe a third flashcard on legal accountability for election subversion. The fact that the fake elector scheme led to numerous state-level criminal indictments by 2024 underscores that tampering with the Electoral College or submitting fraudulent documents has serious legal consequences. It reinforces the idea that these aren't just political games, they are potential crimes against the democratic process.
Accountability matters. Good. These parallels really highlight the playbook and the stakes involved. Hashtag V, unresolved constitutional questions, and future risks. Okay, so these clashes in 2025, the executive order, the DOJ pressure, the court battles, they raise some really profound and as yet unresolved questions about the fundamental balance of power in U.S. elections. The most immediate one, of course, is, can a president, acting alone without Congress, effectively remake the rules of federal elections?
Well, the immediate judicial answer, as we've seen pretty clearly from Judges Culler, Catelli, and Casper, has been a resounding no. Federal judges have repeatedly cited the Constitution's clear assignment of election regulation, primarily to the states, with Congress having supervisory and specific legislative power over federal elections. As Judge Casper succinctly put it, the president does not feature at all in this constitutional framework regarding the power to oversee election mechanics.
But Trump's team and the administration, they seem to be pushing a different theory of executive power here.
They are. They continue to press the theory that the president, as the head of the executive branch, can direct how federal agencies engage with state elections. For example, they argue the president can order agencies like the DOJ or potentially others to share data with states, or can condition federal grants administered by executive agencies on states adopting certain practices.
Okay, so focusing on directing the executive branch itself as a way to influence state elections.
Exactly. It's a sort of indirect approach. But the courts, so far, aren't buying that this justifies overriding state laws or congressional mandates. Courts have, up to this point, consistently viewed this as a ruse, essentially, to do via executive order what only proper legislation passed by Congress could legitimately do, especially when it directly impacts core state functions like voter registration or ballot counting rules.
That distinction is critical. Executive orders direct the executive branch. They don't typically create new laws binding on states or overriding Congress.
Precisely. And this leads us to some truly significant what-if scenarios, particularly depending on the future composition and philosophy of the judiciary, especially the Supreme Court. If Trump's more expansive view of executive power eventually found favor in higher courts, maybe a future Supreme Court more sympathetic to theories of strong presidential authority A future president could try to centralize election control in unprecedented ways.
That's a profound implication for federalism. What could that look like practically? Give us some examples.
Well, you could potentially see the Department of Justice or maybe even Homeland Security being used much more aggressively to police state voter rolls nationwide, perhaps based on federal databases. Or imagine federal election funding, maybe HA grants being explicitly used as coercion, forcing states to adopt specific, perhaps highly partisan election practices favored by the party in power in Washington.
Like mandating certain types of voting machines or voter ID laws.
Potentially. Or a president could try to unilaterally alter federal forms or guidelines related to elections, bypassing both congressional debate and the established state input processes like the one the EAC normally uses.
Has the current Supreme Court weighed in on this specific kind of executive action regarding elections?
Not on this exact issue, no. The current Supreme Court's conservative majority has not weighed in on this specific question of presidential power versus state congressional power in setting election mechanics via executive order. However, it's important to remember that even conservative legal figures, historically, have often held that states administer elections and federal intervention requires clear congressional authorization. That's a traditional conservative view rooted in federalism.
We saw that principle in cases like Shelby County, right?
It's exactly. In Shelby County v. Holder back in 2013, the conservative majority struck down a key part of the Voting Rights Act, the preclearance requirement, precisely on federalism grounds. They emphasized state sovereignty in election administration and argued that the federal oversight formula was outdated and infringed on that sovereignty. Ironically, that ruling limited federal power designed to protect voting rights, arguing for state control. Now, the question is whether that same principle would be applied to limit executive overreach imposing rules on states.
So if the court's composition or its legal philosophy were to shift significantly, maybe towards endorsing a stronger unitary executive theory, it could be a seismic shift in how U.S. elections are run.
It absolutely could. For our listeners, when we talk about the unitary executive theory here, we're essentially referring to a legal theory that posits the president has broad inherent authority over the entire executive branch, giving them sweeping power over agencies and their actions, potentially allowing them to act more independently of Congress in certain areas.
And applying that to elections would be radical.
Yes, if the court endorsed that view in the election context, it would effectively be a green light for presidential directives on elections that bypass Congress. This would truly upend 2 centuries of practice and invite partisan abuse on a scale we haven't seen. Imagine a future Democratic president unilaterally imposing nationwide mail voting rules, or maybe automatic voter registration by executive order.
Or a Republican president banning certain types of voter registration drives or imposing strict voter ID nationwide by fiat.
Precisely. It cuts both ways and would politicize election administration from the White House down in a way that's fundamentally different from our current system. For now, as we've seen, the judicial bulwark, particularly at the district court level, is holding. It's providing critical protection against such overreach. But that bulwark, quote, is only as strong as the judges and justices in place.
So future appointments matter hugely.
Immensely. The political landscape, particularly the outcomes of future presidential and Senate elections, could determine the future composition of the courts that will ultimately referee these very disputes over federal power in elections.
Okay, that's the big question about presidential power. Another open question is just how far state resistance can go without triggering deeper constitutional crises. Like, if the DOJ insists on getting sensitive voter data under these broad demands, and a state flatly refuses, citing its own laws and the Constitution, what happens then?
That could certainly lead to serious confrontations. We might see federal subpoenas being issued to state election officials. That could trigger intense legal battles directly pitting federal power against state sovereignty, likely invoking the Elections Clause of the Constitution, which gives states primary power but allows Congress to alter regulations, and the 10th Amendment, which reserves powers not delegated to the federal government to the states.
It sounds like uncharted legal territory in some ways.
It is. In terms of this kind of broad federal demand versus state refusal outside of specific congressionally authorized contexts. While it's true the federal government does have some explicit election powers, Congress, for example, sets the time of federal elections and has passed laws like the NVRA and HAV that establish certain baseline rules outside of specific congressional action. The executive branch's tools to compel states are arguably quite limited.
What about Trump's call for a special prosecutor for 2020 election fraud within the DOJ? If that office were created and acted aggressively, what are the implications for these state-federal relations?
That's another potential flashpoint. If such an office were created and pursued aggressive, broad investigations into past or present elections, it could certainly clash directly with state election officials and even state laws. For instance, if a state constitution or statute explicitly protects voter information privacy beyond what federal law requires, a federal special prosecutor's demands for that data could create a direct legal conflict. Who wins?
It tests the line, doesn't it?
It constantly tests the line between legitimate federal enforcement of specific federal election laws, like prosecuting someone for proven voter fraud, versus what might be perceived as general inquisitions into state-run processes without clear justification or specific allegations. It raises the question of whether the goal is truly impartial law enforcement or potentially partisan targeting or intimidation.
And finally, maybe the most important question for the health of the democracy. There's the monumental issue of public confidence. How does this constant tug of war, the federal orders, the court injunctions, the DOJ demanding state data, states refusing, how does all this impact whether the voting public actually trusts the outcomes of our elections?
This is perhaps the most profound and potentially lasting risk. Federal overreach in elections, especially if it's perceived by the public as politically motivated, could seriously backfire by undermining trust in outcomes. We already know from years of polling data that many Americans are confused or suspicious about election processes, largely due to the relentless, often baseless fraud allegations they hear.
So this could make it worse.
If the voting public perceives elections as just a partisan tug of war, with headlines dominated by federal power plays, court battles, data seizures, states resisting, it may very well erode the basic acceptance of results, regardless of who wins. People might just throw up their hands and say the whole system is rigged or broken.
We saw in 2020 that while institutions largely held courts rejected challenges, state-certified results, a significant minority of the population still believed the fraud narrative pushed by the losing side. What about in 2025 and 2026, facing these new pressures? Will the average voter believe that elections are being conducted fairly, or will they increasingly see them as under siege by Washington or manipulated by whichever party is in power?
The answer may depend heavily on whether these federal pressures continue unabated and are maybe even validated by higher courts, or if they are definitively struck down and discredited. As one state official put it regarding the DOJ's broad data intrusions, "We have laws to prevent exactly this kind of abuse of data. We intend to stand by them." That sentiment of state officials protecting their voters and processes is strong.
It comes back to that decentralized nature of U.S. elections.
It does. The integrity of U.S. elections has always relied heavily on decentralization and local trust. People tend to trust their local election officials more than distant federal authorities. The current federal pressure directly tests whether that ethos, that foundational decentralized structure built on local administration and trust, can survive what is clearly a determined centralized challenge to the way our elections have traditionally been administered. Mega recap plus flashcard bullets, Section V.
Okay, this section really dug into the deep constitutional questions and future risks. Let's capture the essence with some flashcards. What are the key unresolved issues?
All right, first flashcard. Presidential power versus state congressional authority in elections. This is the core constitutional conflict. Can the president use executive orders or agency directives to fundamentally change election rules set by states and Congress? Lower courts so far say no, emphasizing the president's lack of a direct constitutional role. But the question remains open, especially regarding potential Supreme Court views and the unitary executive theory.
A fundamental power struggle.
Second, limits of state resistance and potential crises. How far can states legally go in refusing federal demands, like DOJ data requests, based on state law or the 10th Amendment? If push comes to shove with subpoenas, could it create a constitutional crisis? The precise limits are untested in this specific context.
The boundaries of federalism under pressure.
Third, impact on public confidence. This ongoing battle, federal intervention versus state resistance, court fights, fraud, claims risks further eroding public trust in the fairness and legitimacy of election outcomes. If elections are seen purely as a partisan battlefield, the acceptance of results, which is crucial for democracy, could weaken significantly.
The danger of eroding trust. And let's reiterate two earlier flashcards that are central here.
Definitely. Reiterate. State authority over elections. The president has no direct constitutional role. An election assistance commission, EAC, independence attempts by a president to command the EAC raise serious legal issues and have been blocked by courts, reinforcing the limits on executive power over even federal election bodies. #6. Deconstructing the election integrity justifications.
So all of these federal moves we've been discussing, the executive order provisions, the sweeping DOJ data demands, they've all been justified publicly under the banner of election integrity. The Trump administration explicitly claims these measures are urgently needed to prevent fraud, particularly non-citizen voting, and to ensure only eligible citizens participate. But let's critically unpack those claims. How do they stack up against the actual facts and evidence? Let's start with the first big claim. Widespread non-citizen voting requires mandatory proof of citizenship for registration.
Right, that's the core justification given for that part of the executive order. The reality, however, based on decades of research and official investigations, is that voting by non-citizens in federal elections is already illegal in all 50 states. And crucially, documented cases are exceedingly rare.
So those claims of widespread non-citizen voting are simply not backed up by evidence, despite being such a persistent talking point.
That's correct. Trump and his allies have long alleged widespread non-citizen voting, often throwing out huge numbers, but without any credible evidence to support them. For instance, the claim that millions of illegal votes cost him the popular vote in 2016 or influenced 2020 has been repeatedly and thoroughly debunked by fact-checkers, academics, and even government investigations. Remember Trump's own Presidential Advisory Commission on Election Integrity, the Kobach Commission? It was disbanded in 2018 without producing any evidence of widespread fraud, and the GOP-led audit in Arizona after 2020. It also found no significant non-citizen voting.
And Judge Kasper explicitly addressed this in her ruling.
She did. In her ruling blocking the proof of citizenship mandate, Judge Kasper specifically noted that Trump's claims of rampant non-citizen voting were baseless and not borne out by any record presented to the court. This makes requiring documentary proof of citizenship seem like a classic solution in search of a problem, and, critically, one that would very likely disenfranchise far more legitimate voters than it would ever catch ineligible ones.
How many legitimate voters are we talking about potentially being disenfranchised by such a requirement? What's the scale of that risk?
Well, studies estimate that a significant number of Americans, perhaps an estimated 21 million U.S. citizens, lack ready access to the specific citizenship documents typically required by these laws, like a passport, birth certificate, or naturalization papers.
21 million. Who falls into that category?
This group often includes elderly citizens whose birth records might be missing or hard to obtain, low-income individuals who can't afford the fees or time off work to get documents, people born outside hospitals, especially in rural areas or historically marginalized communities, and disproportionately voters of color.
And we have real-world examples of this impact, don't we?
We do. Kansas, for example, implemented a proof of citizenship law for voter registration about a decade ago under then-Secretary of State Chris Kobach. It was later struck down by federal courts after evidence showed that tens of thousands of legitimate voters were blocked from registering, while the state could identify virtually no fraudulent voters attempting to register who were stopped by the law. The cure was far worse than the alleged disease.
So the current safeguards under the NVRA, the National Voter Registration Act, are already considered sufficient by courts and most experts.
Yes. The existing system requires applicants to provide an identifier, like a driver's license or social security number, which allows states to check databases like the DMV or SSA records. And importantly, applicants must swear under penalty of perjury that they are citizens. Falsely registering is a felony offense with serious consequences.
So there are already mechanisms to verify and deter.
Right. The existing federal form already guards against non-citizen registration through attestation and data checks. Adding a mandatory passport or birth certificate requirement would mainly serve, critics argue, to erect new barriers for eligible voters who simply don't have those specific documents readily available. Tellingly, the White House's own rationale for the executive order when promoting it reportedly pointed only to vague doubts and conspiracies about non-citizen voting, not actual findings or data showing it was a significant problem.
Okay, so the non-citizen voting justification seems weak based on evidence. Next, let's address the second claim. Late-arriving mail ballots are a source of fraud or confusion, and a hard deadline, ballots must be received by Election Day, is needed for public trust.
Right, this was the justification for that part of the EO, banning the counting of ballots postmarked by Election Day but arriving afterwards. Again, the reality is that states have long managed their own mail ballot deadlines, including these grace periods, with absolutely no evidence that they cause fraud or uniquely undermine trust. As we mentioned earlier, 18 states, a cross-section of red and blue states, plus D.C., and territories count ballots postmarked by Election Day, typically accepting those that arrive within a few days after, according to state law.
And these grace periods serve important purposes, right?
They do. They accommodate military and overseas voters covered by federal law, UOKFIO, voters in remote areas with slower mail service, and they account for unforeseen postal delays that are outside the voter's control. These laws allowing grace periods were on the books in most of these states well before the controversies of 2020 and haven't led to documented fraud or successfully contested results based on the practice.
We heard a lot in 2020, though, about suspicious ballots being found after Election Day, which fueled this narrative that counting after Election Day is inherently suspect.
Indeed, that narrative was a staple of Trump's 2020 election challenges. But subsequent audits, recounts, and court reviews, even in Republican-led states like Georgia and Arizona, consistently confirmed the legitimacy of those ballots counted after Election Day, according to state law. Critically, no court or election commission has found that postmarked but late ballots led to fraud. These are valid votes cast by Election Day, as evidenced by the postmark, merely delivered later due to mail transit times.
And doesn't federal law itself require counting some late ballots?
Yes, federal law, specifically the Military and Overseas Voter Empowerment Act, MOVE Act, requires states to count valid ballots from military members and citizens living overseas if they're postmarked by Election Day and arrive within the state's established deadline. So the principle is already embedded in federal law for certain voters.
And Judge Casper pointed this out, too.
She did. Judge Casper's injunction powerfully highlighted that nothing in federal law bars states from counting such ballots from domestic voters if state law allows it. The Trump order was attempting to impose a restriction that Congress itself chose not to mandate for domestic voters. Far from improving integrity, experts argue an Election Day receipt rule would likely throw out thousands of lawful votes, disproportionately affecting male voters, who often include urban residents, young people, the elderly, voters with disabilities, and yes, often lean Democratic. This disparate impact leads many critics to suggest a possible underlying partisan motive beyond simply fraud prevention.
And it could actually hurt confidence.
Absolutely. It would directly conflict with what voters in many states have been told for years, that as long as they mail their ballot by Election Day, their vote counts. Suddenly invalidating those perfectly legal votes would deeply undermine public confidence, not bolster it. The courts recognize this significant potential harm to voters relying on existing rules.
Okay. Finally, let's look at the third major justification underlying the EO and especially the DOJ actions. That a uniform federal approach is needed because states can't be trusted to maintain accurate voter rolls or enforce rules effectively. Hence, the DOJ must step in heavily with these data demands.
This is the argument used to justify that unprecedented DOJ dragnet for state voter data.
Yeah.
While obviously improving election administration is always a worthy goal and a work in progress, the reality is that states by constitutional design have primary responsibility for elections, and most objective analyses conclude they largely do a capable job, often under difficult circumstances and with limited resources. And importantly, federal law already provides tools for the DOJ to act when states genuinely fail in their duties.
Like what?
The DOJ can, and does, sue states under existing provisions of HVA or the NVRA if they fail to maintain accurate voter rolls according to federal standards, like removing ineligible voters in a timely manner, or if they violate voters' rights. In fact, the DOJ recently sued North Carolina's State Board of Elections under the NVRA for allegedly not adequately removing inactive voters from the rolls. This demonstrates that normal, legally prescribed channels for federal oversight already exist and are used when specific problems are identified.
So a broad DOJ dragnet for voter records across 19-plus states without specific allegations is different.
It's unprecedented, yes.
Yeah.
Especially the demand for entire state voter files containing sensitive personal information.
And states have been vocal about their concerns here, particularly regarding voter privacy.
Absolutely. State officials across the board worry about privacy and federal overreach, and arguably rightly so. For example, the DOJ asked California counties for not just the number of non-citizens they might have removed from rolls, but also their actual names, birth dates, and ID numbers, raising significant privacy red flags under state law. The sheer scale of the mass request to 15-plus states makes it seem more like a political fishing expedition than targeted enforcement, based on specific, actionable intelligence of widespread problems.
And crucially, there's no evidence presented to justify this level of scrutiny.
Exactly. No evidence of widespread voter fraud or systematic malfeasance in state voter rolls has been presented by the administration to justify this kind of sweeping national inquiry. On the contrary, multiple state-level reviews and audits, often initiated or led by Republican officials after the 2020 election, precisely to look for fraud, consistently concluded that voter rolls had only trivial numbers of improper registrations, and those were usually caught by existing list maintenance processes and rarely, if ever, resulted in fraudulent votes being cast.
Can you give an example?
Sure. That Texas 2021 audit, which was championed by Trump allies, reviewed millions of votes in 4 large counties. It found only a handful of potential non-citizen registrations out of 11+ million voters statewide. And even those few potential cases weren't confirmed instances of fraud or illegal voting. They were flags requiring further investigation.
So the integrity justification here, focusing on voter roll accuracy and non-citizen voting, seems to be chasing phantom problems when you look at the actual data.
It does seem that way based on available evidence. The core fact remains stubbornly consistent across numerous studies and official reviews. Election fraud in the U.S., including voter impersonation, double voting, or non-citizen voting, remains exceedingly rare, unquote. Studies consistently put the incidence rate at fractions of a percent. It's just not a widespread phenomenon. Most election experts widely agree that the greatest threats to election integrity today are actually more insidious ones. Things like sophisticated cyber attacks on election infrastructure, foreign or domestic disinformation campaigns designed to mislead voters or suppress turnout, and increasingly, efforts from within to sabotage the certification of legitimate results.
And the DOJ's traditional focus aligned more with those threats.
Yes. Traditionally, the DOJ's voting section focused on protecting against discrimination, ensuring compliance with federal voting laws like the VRA and NVRA, and combating foreign interference threats that align more closely with what experts see as the real dangers. Instead, the current integrity push seems fixated on types of fraud, like in-person impersonation or registration issues, that state and local officials already have procedures to handle, and which all evidence shows are minimal problems. Therefore, many critics argue these recent federal interventions appear pretextual, a pretense to justify policies that could suppress turnout or provide a basis to challenge unwelcome outcomes, rather than addressing genuine evidence-based threats to election integrity.
And the courts seem to agree with that assessment.
Largely, yes. The courts that ruled on the executive order have seen through this, describing the EO's key provisions as an unconstitutional attempt to interfere with states' fundamental responsibilities, based on justifications not supported by facts. The swift injunctions followed precisely because these election integrity justifications didn't hold water when weighed against the empirical reality and the established constitutional structure. Mega recap plus flashcard bullets, Section 6.
Okay, that was a thorough deconstruction of the election integrity justifications. Let's lock in the key counterpoints with our final set of flashcards for this session.
Good idea. This is crucial for separating rhetoric from reality. First flashcard. Non-citizen voting is exceedingly rare. Claims of it being widespread are repeatedly debunked by evidence and official investigations. It's already illegal, and documented cases are minimal. Therefore, proof of citizenship laws are often seen as disenfranchising eligible voters to solve a non-existent problem.
Got it. Myth versus reality on non-citizen voting.
Second, voter fraud is minimal overall. Numerous investigations, audits, and studies consistently find that all types of voter fraud, impersonation, double voting, etc., are extraordinarily infrequent in the U.S., far too rare to alter election outcomes. The data does not support the narrative of rampant fraud, often used to justify restrictive voting laws or broad federal investigations.
Minimal fraud overall. Third point related to registration.
Third, reiterate federal voter registration form requirements. The national NVRA form does not require documentary proof of citizenship, like a passport birth certificate. It relies on attestation under penalty of perjury and database verification using existing ID numbers. Adding document hurdles goes against the NVRA's design and intent.
NVRA doesn't require documents. What about mail ballots?
Fourth, many states count late-arriving ballots legally and securely. Remember, 18 states plus D.C. territories accept mail ballots postmarked by Election Day if they arrive within a legal grace period. There is no evidence this established practice leads to fraud. Federal law even requires it for military overseas voters. Banning it overrides state law without cause.
Grace periods are normal and legal. And finally, The EAC point again.
Yes, worth repeating because it was targeted.
Yeah.
Election Assistance Commission, EAC independence. The president cannot unilaterally direct EAC policies like changing the form or decertifying machines. Attempts to do so were blocked by courts as violating its statutory independence and the separation of powers.
Excellent. So the justifications used for these federal interventions really crumble under factual scrutiny and an understanding of existing laws and constitutional structure. Hashtag outro. Well, what a journey through the intricate and, frankly, high-stakes landscape of election administration and federal power. The past year, as our sources document, has clearly seen a profound test of American election administration, really highlighting that ever-present tension between, federal ambition and the deeply rooted constitutional framework of state authority.
This deep dive has revealed several critical insights, I think, as we navigate this complex landscape. First, when it comes to constitutional scrutiny, the judiciary, at least so far, has consistently reaffirmed that states, not the president, hold primary authority over election mechanics. While Congress possesses supervisory power through legislation, direct executive fiat from the president trying to dictate election rules has been consistently rebuffed by the courts based on that fundamental constitutional structure.
Second, we've seen how even independent bodies like the EAC, specifically designed for nonpartisanship and insulation from political pressure, can find their independence under threat. Yet judicial intervention and their robust statutory design requiring bipartisan consensus have provided crucial bulwarks against that executive overreach. It demonstrates the resilience but also the potential vulnerability of these institutions. Third, and perhaps most critically for you, the informed citizen, is that evidence matters. Claims of widespread voter fraud, especially regarding non-citizen voting or systemic issues with mail-in ballots, consistently fall apart under factual scrutiny. The data simply doesn't support those narratives. It underscores the absolute importance of relying on verifiable facts and credible sources over unsubstantiated allegations when we evaluate claims about our elections and proposed policy changes.
Yeah, separating signal from noise. And fourth, understanding those historical echoes, looking at places like Hungary and Brazil, and even our own recent history with the 2020 fake electors scheme, reveals a clear pattern. It shows attempts to undermine electoral integrity often occur through legalistic manipulation or by eroding public trust over time. These precedents really underscore the vigilance required from all of us to protect democratic norms, recognizing that such efforts are often systematic and multi-pronged, targeting the very foundations of trust and process. So, as these legal battles inevitably continue, and as we look toward future elections, maybe consider this final thought. How might an informed citizenry, armed with facts and a deep understanding of our constitutional structure, best resist efforts to weaponize these election integrity claims? And instead, how can we reinforce the genuine integrity and the public trust that our decentralized, state-run election system has historically relied upon?
What role do you play in upholding the foundational principles of a fair and transparent electoral process in your community, in your state, and in the nation? This deep dive, as always, is just the beginning of your journey into understanding these crucial dynamics. Thanks for joining us.